You have legal questions. Amy the attorney has the answers. Welcome to today's show. And here's Amy.
Okay, let's talk about the servers and bartenders first. We're going to set aside the independent contractor for right now, but the servers and bartenders and other people, are these people, is this the kind of worker that clocks in and out, or do they write their time card? What is the normal, if there is a normal situation?
Yes, the vast majority of servers usually use a traditional time card that they swipe, or a time punch. That's getting a little bit outdated, but there's a time clock where they swipe in and they swipe out.
Okay. And is some of the cases that we're talking about here, are they being asked to work after that swipe is taken? Or are they asking to be worked before or after they've punched in?
Yeah, that's a great question. So the cases where somebody, and I've got some great examples of these, but the cases where somebody actually has to do some work before they clock in, those are called off the clock cases. So for servers and bartenders, that's not exactly what's usually happening, although we've seen it happen. The primary situation for a server or bartender is, I've clocked in, now I've got to go do 2 hours of cleaning or prep work. It's in the industry often called side work. And I got to go do this, and I'm not even able to make tips during this time period. And so the rule is, if I'm a server or bartender and I'm spending more than 20% of my shift doing these things like cleaning and prep work and side work, then all of a sudden I'm really doing too much. So I can do a little bit and they can still pay me that reduced minimum wage. But once it hits 20%, which is about an hour out of a 5-hour shift, now you got to start paying me full minimum wage for that time that I'm working.
Okay, so even if say, okay, I had to do an hour, I have a 4-hour shift, I did an hour's worth of side work, and heads up, I did wait tables for 13 years, so I know a little bit about that. But can they make up in those 3 hours where I'm waiting tables, say like, okay, you know what, I had seven tables and I got paid, I got tipped $10 on each of them. So in that 4-hour shift, I did make $70, but the first hour was spent on side work. Does that make sense?
Yes, they can't do that. Okay. So even though I might be making a much higher than minimum wage overall, once I've added in my tips, if I'm doing more than 20% non-tip producing work, that means that the time I'm spending doing that non-tip producing work has to be paid at the full minimum wage.
Okay.
No matter what I made.
Okay. And I want to kind of walk this through a little bit. So somebody is waiting tables. They're getting an hour's worth of side work. It's a 4-hour shift. What are the steps? I mean, how would they, when they came to you, what would they bring with them, or what information would you need?
Right. Very little, frankly. One of the things about wage and hour law is you don't have to show up with a bunch of documents. You don't have to show up with a bunch of evidence. You have your testimony. You have your story. And in wage and hour law, that's typically enough, because the employer has the burden of making sure they're paying their employees right. So if you come forward and you say, here's what's happening, that's usually enough for us. And then we, the lawyers, we go out and we get the documents that we need to get. We get, in fact, one of the things in the server cases that we use a lot of is the point of sale records. So we can actually take the computer records and we kind of know what you're doing. In other words, if you're clocked in, but you don't have a table for 2 hours, we know that by looking at the point of sale records. So it's not something that our clients necessarily need to have. We can go get that.
Okay. All right. So you said that there was this 20% rule. Is that something that an agency of the government, says you can't do 20%? I mean, who is saying this 20%?
Right. So this has been a topic of a lot of litigation over the last 15 years or so. And so it originated from the Department of Labor had a rule that if a Department of Labor investigator came out, they'd say 20% seems about right. But what happened is courts started looking to that and they said, yeah, this 20% rule seems like a reasonable way to prove your case. So it does depend which court you're in, but the courts around this area, the Kansas City area, have followed the 20% rule, and it's pretty much good law at this point.
Okay, with this paycheck theft, with these cases, do they all sort of follow the same path in terms of when they come to you and they hire you, or is the independent contractor case follow a different case than the servers and bartenders or off the clock cases?
In terms of how the case originates?
In terms of like how it goes in terms of suing somebody and what the client would expect to go through. Is the process similar? Or are they different for all three of those cases?
It's pretty darn similar. So the process is, through a variety of ways, the client finds themselves to our office, and usually they don't know for sure whether there's a violation. And sometimes they've come to us and they're complaining about being treated unfairly in a different way. And we say, well, the law doesn't really protect you there, but where it does protect you is I can see you're being paid incorrectly. But yes, in terms of we look at the case, we talk to the client, we realize there's a case, they all play out pretty much the same way after that.